Well, it's good morning, and it's an equally strong, big pleasure and honor to be able to chair this third panel of this morning with two such prestigious, well-known, excellent panelists. My colleague Laurence Boisson de Chazournes from Geneva, my colleague Giorgio Sacerdoti from Boccone, Milano. I will do as my predecessor in this position. I will not introduce them to you. They don't need to be introduced. And for those of you who would like to see whether their recollection of their careers is correct, please have a look at the information which the organizers have kindly presented to us. So without saying any much more, please, Laurence, you have the floor.
Thank you very much. It's, as always, a pleasure to be in Luxembourg at the Max Planck Institute. My topic is sort of a bit dry, so I prepared an outline, and it's distributed so that you would have the provisions that we will be discussing during this panel. So, as you've seen in the program, it's BITS and the applicable international law in investment dispute settlements. So why do we have such a question? Because, in fact, it's an important issue, and it's an important issue in the context of, for example, of the EU proposal. But before I speak about the EU proposal, I think that I should put this question into context. So, as words of introduction, why is the issue of applicable law important? I think it's important because it has implication in terms of enforcement of the award. If you think of the ICSID Convention, Article 52, under Article 52, there could be a problem because there's been a mistaken application of the law by the tribunal, or failure to apply the applicable law, and that could be grounds for annulment. So that is something which is important. Now, in the context of the discussion of the appellate body, the issue of the applicable law is also going to be important. What is the set of rules that are going to be taken into account if there is an appeal? And then it seems to me that the applicable law is also very important in terms for favoring the predictability. And I would prefer the term predictability rather than the one of consistency, because I think that that is one of the core functions of a judicial system. So as you can see in the outline, I think that before, to understand why we are speaking about international law in the context of investment arbitration, we have to discuss about, but should it be applied, and does it have a role to play? And most of the discussion so far has turned around the interpretation of Article 42 of the ICSID Convention. And you have the text of the ICSID Convention in the outline. And I'd like to refer to something which has been said about Article 42. And it has been said that if you don't have an agreement between the two parties, you have what is provided by Article 42. And the question is that, and that has been posed by Michael Risman and Manu Shasanjani, is it the product of a poor drafting, or is it a masterpiece of constructive ambiguity? And I think that is a fair question. It's an article that is going to be published in honor, in the context of the 50th anniversary of the ICSID Convention. So when we speak about the application of international law, there are various scenarios, and I've listed them. The first one is the role of international law in the presence of a choice of law provision. What is interesting is that very few bits provide for international law as the applicable law, and very few contracts provide for international law as the applicable law. So that's the first scenario. The second scenario, it's the role of international law in disputes lodged pursuant to a contract with a choice of law provision in favor of domestic law. And there, interestingly, if you look at the case law, it's interesting to see that international law is always going to be somewhere. So I would say that it has mostly a supplementary role to play, even when the parties have chosen to apply domestic law. Now, third scenario, the role of international law when a case is lodged pursuant to a treaty which does not confer a choice of law provision. So no agreement between the parties. And there, you can refer, there is a huge literature about that, but you're going to see that quite interestingly, there is a way to include both domestic law and international. So international law, but domestic law is never going to be away from the spectrum. So that means that the practice so far has favored these links which exist between international law and domestic law. Fourth scenario, it's when multilateral treaties are referring to international law only. And I'm speaking of existing multilateral treaties dealing with investments. So this is the case of NAFTA, and NAFTA has a provision saying that international law is the applicable law. This is also the case of the Energy Charter Treaty, which refers to international law as the applicable law. Now, a question that we can pose ourselves, and that is that, does it mean that the more multilateral a treaty is, the more internationalized its choice of law, its provision is going to be? So I think that's a question, and I would say yes and no, and we will see why. Now, so those are the scenarios, and as you've seen, international law is always somewhere, as well as domestic law when there is no choice by the parties made in terms of the applicable law. Now, what rules of international law should apply? And I think that's something which is important, and it's going to be important in the context of also the EU proposal. So it's the scope of reference to international law. First point that I identified, that should we speak of rules or principles, and there I would refer you to the Bible on the Exit Convention, I mean the excellent writings of Christoph Schroyer, and you will see that there is a discrepancy between the French version and the English version. The French version speaks of principe de droit international, and the English version refers to the rules of international law. And I think that rules, to me, seem a bit better because it's broader. In fact, it's international law in its broad acceptance, which is referred to. Interestingly enough, in the first drafts of the Exit Convention, there was an explicit reference to Article 38 of the ICJ statute listing, and which is referring to the sort of classical sources of international law. This reference to Article 38 of the statute disappeared in the course of the negotiations of the Exit Convention. But what is interesting is that it seems, and looking at the practice, that the sources as identified in Article 38 are important. Now, what is also going to be important in terms of the applicable law is that when you refer to a bilateral investment treaty, it's an instrument of international law. So it's going to be the lex specialis, which is going to find application. So we're going to be looking at the BIT and the other sources of international law which might have a say, and which in fact have a say. So first, customary international law. I'm not going to spend too much time on that because that was already discussed this morning, but the customary rules of interpretation as derived from the Vienna Convention are very important, and they are fundamental, and they are referred to by tribunals. Interestingly enough, the Vienna Convention are referred to for interpreting treaties, but also for interpreting national legislations. And you might want to think of the CEMEX case and other cases. So that is important. Now, other rules of international law, of customary international law, which are particularly important in the field of investment law, the rules in relation to state responsibility. And the draft articles of the international commissions are good examples for that. And other examples are linked to the discussions that we had between Jeremy and Stefan when Jeremy alluded to the interpretation of the fair and FET treatment, the fair and equitable treatment provision, and you have this relation with customary international law. Some treaties would provide the fact that the definition should be in accordance with customary international law. Some others are going to have a more specific interpretation, but international law is always going to be somewhere when interpreting this provision. The same could be said about reparation compensation that was discussed by Christoph Schroyer and Alain Pellet. Now, another source of international, general principles of international law, or principles of international law which There, it seems to me that a lot of procedural matters are going to be important for investment tribunals, and in fact, they've been important. Think of the clean hand doctrine, think of the estoppel doctrine. Think also, I think, of an emerging rule, which is the prohibition of corruption, which is more and more referred to by investment tribunals and other circles. Another type of source which is important, the decisions of courts and tribunals. And there, the decisions of the International Court of Justice play a particularly important role. And I would refer you to the article of Alain Pellet in the ICSID review, where you see that investment tribunals have referred quite broadly to decisions of the International Court of Justice. And Alain referred to the elucidating function of these decisions. I think that is true. Other decisions have been referred to of other courts, and I think, for example, of the decisions of the European Court of Human Rights when it comes to interpret the criteria, the test of proportionality, and references have been made to the decisions of the European Court of Human Rights. So, is it a supplementary means of interpretation, or is it a principal means of interpretation? I would tend to consider that more and more decisions of other courts and tribunals, and especially the International Court of Justice, is acquiring an important function for clarifying the law applicable in an investment treaty. Now, last point, which I think is important, it's this emerging practice of standards, guidelines, soft law instruments, and more they're referred to by investment tribunals. So obviously the typical examples are the IBA guidelines with reference to evidence or party representation and so on. But I would claim that I think that all the so-called soft law instruments dealing with human rights, environment, such as the Equator principles, but other ones, are going to acquire more and more an important role to play, especially with respect to the conduct of environment impact assessment. And that means that they're also going to be there in the context of an investment dispute. Last, third point in this presentation, so where do we stand with respect to the importance of international law? And the question that I posed in the third part is that, are we moving from a supplementary role for international law to a monopoly role in investment arbitration? And why am I raising this question? I'm raising this question because if you look at the EU proposal, you're going to see that, and you have it in the page that was distributed, that international law has acquired primacy. In making its determination, the tribunal shall apply the provisions of this agreement and other rules of international law applicable between the parties. There is also an explicit reference to the rules of the Vienna Convention with respect to interpretation of treaties. And then, paragraph 3 of Article 13, it says, for greater certainty, pursuant to paragraph 1, the domestic law of the parties shall not be part of the applicable law. So I think that is interesting, and that it continues and it says, for greater certainty, the meaning given to the relevant domestic law made by the tribunal shall not be binding upon the parties, and so on, and domestic law should be looked at as a fact. So that's the traditional conception of the importance of domestic law from the perspective of international law. Now, this is interesting, and we don't speak of the elephant in the room. There is nothing about the regional law, which also is going to be important in the context of the EU proposal. But I'm not going to mention this elephant. It's white and big and it's stationed not too far from here. But I think it's interesting because there we see that international law is used as a means of protection. A means of protection which is going to guarantee the autonomy of the functioning of investment arbitration. Now, other issues which are important in the context of the EU proposal with respect to the treaty with the United States is the fact that you have more and more provisions which are substantive and developed. We spoke of the FET, we spoke of expropriation, and so on. And if you look at these provisions, you're going to see that there are references to international law. Okay, so international law is everywhere, I would say, in the context of the EU proposal. And what I think we can also test and see with the EU proposal is that we're moving towards a substantive instrument with respect to investment treaty, more than a procedural instrument. And that, I think, is an interesting turn in the field of investment protection. So substantive provisions, reference to international law, as we see, if we look at the EU proposal, what I've called the lex specialis is quite broad in scope. So the question, and I don't have any answer for the time being, but what is going to be left to the other sources of international law? Because already the EU proposal is including a lot of references to international law in its multiple aspects. One thing that I'd like to mention with respect to the EU proposal is the fact that primacy is given to international law. I think that the fact that there is a proposal for an appellate body is meaningful, especially because the inspiration, I think, is very much linked to the WTO experiment. And so international law in the context of an appellate mechanism is going to play an important role. Now, another point which I found interesting is the fact that you know that in the proposal, we've mentioned that this morning, there should be a standing tribunal and there would be an appellate mechanism. And when we look at the profile of the persons who could potentially sit or be identified, they are asked, among other criteria, to have a broad knowledge of public international law. And it's interesting because that's and Colin, maybe you could correct me, but I think it's the only place in the context of this proposal where we refer to public international law. Otherwise, it's international law. And I think rightly so, because international law is broader than public international law. Now, we have this, and we have another regulatory proposal, which is maybe more firm, which is the Trans-Pacific Partnership between the United States and other 11 countries. And there, if you look at the choice of law provision that you have on the sheet, you're going to see that it's more like the ICSID convention. It's a mix, it's agreements, and if not, I think you will have the domestic law, choice of law provision, and international law. So monopoly, words of conclusions, monopoly, yes and no, I think. And maybe that there is a particularity for the EU proposal, and maybe it's due to the special structure of the European Union, and that could be an explanation. Now, when we refer to international law, I think the scope of international law should be understood in a broad manner. Okay, and I don't think that we should restrict it to what we call public international law. It's broader, and the following panel is going also to bring light on this matter. Now, I've spoken of international law, but I think that domestic law has an important role to play in the context of investment treaty. And I'm in line with what was discussed in the first panel. It seems to me that when you look at the practice of states in Africa, in Latin America, where there is more and more attention given to constitutional values with respect to the exploitation of natural resources, access to basic needs, and so on, I think it's and when you know that investment arbitration is in fact dealing with these issues of exploitation of natural resources, the providing of services, and so on, I think it's very important that we have, in fact, a link with domestic law and the agreed values. And to render justice to the EU proposal, it's there in the EU proposal. It's in Article 13, paragraph 3, and it says that where the tribunal is required to ascertain the meaning of a provision of the domestic law of the parties as a matter of fact, it shall follow the prevailing interpretation of that provision made by the courts or the authorities of that party. So that, I think, is something which highlights the fact that we need to have this link between international law and domestic law, and more especially constitutional law. And I would like to note that even NAFTA tribunals, which are required to apply international law, if you look at the Glamis decision, if you look at the Grand River decision, you will see that there is a deference to constitutional law authorities, because there are issues that cannot be dealt with without referring to the authorities in the country which is the respondent. So all that is to say that international law is important, but it's important in a very specific context, and that's the richness of this body of law, is that we have to look at it from a transnational comparative law perspective and public law perspective, looking at the domestic law. Thank you very much.
Thank you very much, Laurence, for that presentation. Brilliant as to contents and as well as to keeping the time. So, Giorgio, we have been heard that the relevance of appellate bodies, so maybe you would like also to share some of your experiences as a chairman of an existing appellate body with us.
Well, thank you very much. I mean, it's really a lecture that we have heard from Laurence, so I'm really a little bit embarrassed to say something. I would start from Article 42 of the ICSID Convention. I think, based on interpretation and travaux préparatoires, that text reflected a period when BITs were practically non-existent and reflected a contractual vision. That is the idea that the ICSID Convention was available to parties to investment contracts instead of going to domestic courts, as it has been recalled before, which were in developing countries newly decolonized, to go to an international appropriate forum. So the idea was that basically these contracts, these relationships, are subject to domestic law chosen by the party, or even the principle of conflicts of law, and that international law would be a limit, as it had been said, if domestic law would be found to be contrary to international law, like providing for expropriation without appropriate compensation, then, of course, an international arbitral tribunal would have to apply international law. That was one of the purpose of the impartiality of the ICSID Convention, and would then apply international law, maybe not directly, but rather like a limit to the application of domestic law. Now, of course, this has changed a lot, because in investment arbitrations based on BIT, I would say international law has prevailed. But this is quite natural. I mean, international courts, being their permanent tribunals or arbitration ad hoc tribunals, have to apply international law. They belong to the international systems, and they are there somehow to control that there is no breach of international law. The basic law, invariably, when the claimants, the investors, start case, they complain of a breach of the bilateral investment treaties. That is the base of the jurisdiction and also the base of the applicable law, that certain measures of states have been in breach of the fair and equitable standard, the minimum standard of international law, expropriation, denial of some rights, repatriation of capital, and so on. And in front of international courts, domestic law is facts. They are indeed peculiar fact, but it's facts. If I take from a recent decision of the appellate body, I had already retired from there, the appellate body had clarified that municipal law may serve both as evidence of facts and evidence of a member's compliance or non-compliance with international obligation. It has also said, however, the domestic law is a peculiar fact. You don't have to ascertain just the realization of something in the nature, but something which is issued by a domestic constituency. Examination is a legal characterization by a panel, and it's therefore subject to appellate review under Article 17.6 of the DSU. And the appellate body has had often to say that in order to the examination of a municipal legal instrument will focus on its text, but may also include the context of the provision, the overall structure and logic of the municipal law, In this dispute, that was easy fastener, so domestic provision was the European anti-dumping provisions, China versus the European community. In this dispute, the panel did not review factual elements concerning the application of the article. It didn't need, but it could have, such as pronouncement by EU domestic courts or opinions of legal experts or recognized scholars. So domestic law has to be looked as it is applied and interpreted in the domestic system. And it's somehow so not a direct application of domestic law, but it is to check domestic law obligation and the conduct of the states vis-à-vis the international standard, because usually in investment arbitration, the challenge is against a specific provision, but it can also be against a more general regulation, and here we have recent cases on regulation which are applied in that case, but the investor complains of a damage caused to itself, but it may be more general. A statute, I don't know, we read that Spain has 23 cases against a certain regulation or legislation in Spain withdrawing benefits for the photovoltaic electrical energy, for instance. This is a little bit mindful, I would say, of what happens at the European Court of Human Rights with the decisions of principle, when there is a statute, for instance, providing for a certain mechanism of expropriation, which is found in a specific case to be in breach of the first protocol, and this could be repeated, and then the obligation of the state is to withdraw the measure rather than just provide every time compensation. And in WTO law, we have also this distinction of a breach of a domestic law provision or measure as applied to the specific case or as such, because the provision, like it was found Article 9.5 of the anti-dumping regulation of the community concerning anti-dumping in case of non-market economy, was contrary per se, and the community amended then that provision. So in this sense, I would say there is nothing new in the proposal of the European Commission that emphasizes a lot the fact that international tribunals do not pass on evaluation of domestic law as law. Of course, this is done, we know very well, in order to calm some concern concerning the position that the European Court of Justice could take on that. And I think here we have to go back to principles. I mean, international law courts and tribunals are meant to settle disputes at the international level concerning international rights and duties of states, or in a derivative way for the benefit of individuals in human rights context, or for the benefit of foreign investors when they can act directly under BITs. And therefore, they should not be considered by domestic courts to be an encroachment on their jurisdiction. The European Court of Justice is a domestic court of a national entity in front of international law, like just the US Supreme Court is. And the settlement, judicial settlement or arbitral settlement of international dispute is not only a long-standing institution of international law, but it's recommended by Article 33 of the United Nations Charter. Now, it's true, I would say, and I'll finish, that somehow in investment law, you are in between. Why? Well, because I would say the status of foreign investment in a host country is basically under the domestic law of the country. If an American foreign investor invests in Luxembourg, it's the civil code, the commercial code, the tax code of Luxembourg that will apply. Same if a European investor invests of the United States. And international law, as provided in these treaties with direct access to international justice, is a second layer of protection in case that the domestic law and the domestic jurisdiction are not adequate to international standards. That was a tradition when they were started in the 50s, when new international economic order, no clear standard in customary international law for the protection of the economic interests of foreigners. And then it has developed more and more. You are quite correct. The lex specialis is becoming bigger and bigger because there are more and more substantive provisions in this treaty. So it's fact that also the breach of domestic law is not decisive because it's a breach of the international standard, and for this, the conduct within domestic law or the provisions of domestic law may be relevant. Now, it's true, and I will finish with an example, that, so I would say domestic law before international courts and arbitration should be residual and can interpret concepts of international, because when you say legitimate expectation of an investor, the legitimate expectations in relation with the legal system of the country, if the country has a certain legal system within the regulatory competence, the investor cannot rely on more than the domestic law gives it to it, let's say. It's true that some BITs, they are rather rare, I think, provide that the tribunal will interpret both international law and domestic law. So a provision like Article 42 of the ICSID Convention. I don't think that there have been very many cases where this has had a practical relevance. I may finish with an experience as an arbitrator case. The BIT between France and Argentina provides exactly like this. And there have been some dispute by French investors against Argentina. But what was then the relevance of the Argentinian provision? It came at the end that, as you know, international law is rather vague on how you calculate interest on damages that are awarded. You liquidate if the BIT is silent, simple interest, compound interest, commercial rate or not. So the tribunal asks the parties whether they considered that Argentinian domestic law on the rates of interest were relevant. The tribunal then learned that in Argentina there are several rates: civil interest, commercial interest, when a bank is involved, when you haven't paid. So in practice, it was impossible. It was not relevant for damages under international law, which would be paid in dollars by a ICSID tribunal sitting in at the World Bank. But this could be an idea of something of the domestic law. Then the domestic law would have somehow supplemented international law. Now, the text of TTIP, I think, in this respect, is rather puzzling because it takes back somehow to Article 42 of the ICSID. It looks very much from a domestic rather perspective. It's also, it follows the latest US model bit in that it provides, the hypothesis is that there is an investment contract, an investment authorization. So a breach may be of a specific measure and not an investment made under the general law of the host state where there may be a breach by a specific or general provision of the government or the local authority. But at the end of the day, there's still the reference to international law as may be applicable, and my submission is that international law will always be applicable. Thank you.
Thank you very much for that. Floor is open. Any questions to? Yes, please. There's a gentleman over right in the middle of the room. Maybe you could just simply shortly introduce yourself. That would make it easier for all of us.
Okay.
Thank you.
Thank you. Marco Benetin, Research Fellow here at the Max Planck Institute. My question goes to Professor Boisson de Chazournes, and it concerns the interpretation of Article 13 of the TTIP as it currently stands. And I'm referring to the segment, and I quote, "Other rules of international law applicable between the parties." So how are we to understand its reach? Because does this mean that potentially any treaty could potentially apply in a case? And here I think it's interesting to draw comparison with the case law of interstate arbitration. So if you, for instance, contrast the Guyane versus Suriname arbitration, where a tribunal was willing to apply jus ad bellum rules in a maritime delimitation, which is far removed from the convention in question. And then you can contrast that, let's say, with the Mox plant arbitration in other cases, where tribunals have been much less willing to go for a broad understanding of applicable law and require the applicable law to have a close relation to the topic of the dispute. Thank you.
Could we just simply collect a few questions and then answer them in a row? Christoph Schreuer, please.
I believe that over the history of investment arbitration, there's been a gradual shift from domestic law towards international law. If you look at the drafting of the article, of what later became Article 42, initially there was resistance against including international law at all. And some countries wanted to have investment arbitration only under their domestic law. The compromise was achieved under the leadership of Aaron Broches, and the outcome was that international law would be included, but the domestic law to be applied would only be the domestic law of the host state. That was the genius of Aaron Broches that is apparent in this particular provision, and I agree with Laurence that this was a stroke of genius and not bad drafting, quite on the contrary. In the early cases, in the application of Article 42, there was a doctrine that international law would be applied only for supplementary and corrective purposes, which was relatively narrow. And then came the famous article by Emmanuel Gaillard and Yaspani Fatemi on the meaning of "and" in Article 42. And they say it's not just corrective and supplementary. "And" means "and both are equivalent. With the advent of bid arbitration, there was a further shift towards international law, so much so that many investment tribunals nowadays believe that their only task is to apply the substantive provisions of the bid and nothing else, which I believe is incorrect if there is a broad jurisdictional clause. If the jurisdictional clause says any dispute arising from an investment, any means any, just like "and" means "and that includes also disputes under domestic law, but that has almost been forgotten. I believe that both international law and domestic law are essential and cannot be avoided. Envisage a situation where you have a choice of domestic law only. You still have to apply the Vienna Convention on the law of treaties. You still have to apply the international law of state responsibility and many other areas. Conversely, if you have a provision that says international law only, you can't get around domestic law. You have to ascertain whether the rights in dispute really exist, whether the property really exists, whether the investment has been made legally, whether domestic environmental law has been applied. So I'm a bit skeptical about the EU proposal that only international law should be applied and that domestic law should be applied as a fact. I think that's a typical case of a rose by any other name, just calling it a fact. But in fact, of course, it is law. After all, the EU proposal also foresees an appeal in case of an incorrect application of the domestic law. Of course, you can call it a fact, but an appeal is also an appeal. So the gist of what I'm trying to say, both domestic law and international law are important, and both cannot be avoided. Thank you.
Thank you. Maybe just one more question before I turn the floor back to the panel. That's not the case, then Laurence, please.
The question that I agree entirely with what Christoph has said, and with respect to the scope of the jurisdictional clause, and I think that's an additional element to take into account when we discuss about the applicable law and the scope and of applicable law. Now, to go back to the question, which is a fair question, and I saw it, and I was just thinking, what does it mean? You know, if you look at the drafting, are the rules of international applicable between the parties? And for me, because I'm also someone interested in WTO law, I was just thinking about the way the WTO panel in the GMO case looked at, interpreted Article 31.3 C of the Vienna Convention with respect to other rules of international law. And maybe Colin could give us some insights about this drafting, but I think that we should not have a too formalistic interpretation of it. Should we consider that it's really only the rules when we look at treaty law which are binding upon the two parties? Maybe. But for the EU, there will be an additional element which is going to be complicated because the EU and other 28, 29 member states. So that would be a question. And then with respect to customary international law, I think we are all aware that we should speak of general international law. And apart from the problem of the precautionary principle before this panel, otherwise all other customary rules have been accepted as applicable between the parties. So not a too formalistic interpretation of it, I would suppose.
Well, for the sake of transparency, Colin, would you be able to share some of your knowledge?
Yeah.
I'm not sure that this is. I'm happy to share the information, but I'm not sure there's as much mystery behind this particular phrase, rules of international law applicable between the parties. I mean, you'll see, and you can see very clearly in your paper, Laurence, that similar language is used in US practice, and this is where we drew it from. The precision we've added on applicable between the parties is precisely to make it clear that it's the bilateral rules between the EU and the third country that are potentially applicable and not anything internal. So that's where that little precision comes. But beyond that, yes, of course, we go into more detail in the substantive rules, and there's greater clarity that's provided there. But we're quite convinced that there are a number of principles or rules of international law that may come up and be relevant and that are not explicitly addressed, and those may be procedural or substantive issues. You touched upon some of them yourself in your introduction. If I could also respond a little bit to what Christoph said. Yes, very much largely agree with many of the things that you said. The distinction that we are trying to make, and I think we're pushing it a little bit further because of the debate that there is in the EU about how all of this system relates to EU law, and I think we're going to discuss that later on today. But that was the reason that we had to go into greater detail on this and be clear that, at least in our view, while domestic law is, of course, going to be very important, and you gave plenty of examples of where it would be very important, that it will always be, in those cases, a question of determining as a factual matter what the law is. And the reference in the grounds to appeal to determinations of domestic law is in the context of manifest error of appreciation of the facts. So that fits in that logic of treating these issues as matters of domestic law. But I'm happy to admit that the line is not as clear necessarily in all cases as one would like to think as a matter of theory. Thank you.
Thank you. Giorgio, please.
Well, I think what Colin just said is interesting because, in fact, it sheds some light on the provision about appeal, where the fact that the appeal is ABC, Article 29, has heard an interpretation application of the applicable law, and then would wonder whether this is also domestic law, because under the practice of the appellate body, it may also be domestic law, even if it is a fact, as in the sentence I read, the erroneous appreciation of the domestic law, of the measure challenge, is reviewable in appeal. But here we have, it would not be so, I understand, but the tribunal, another reason, has manifestly erred in the appreciation of the fact, including the appreciation of relevant domestic law. So the manifestly error of the fact, which seems a little bit, I was saying, I don't say excessive, I mean, there would be a first instance tribunal made by competent judges selected by the parties, and we hypothesize that they manifestly err in the appreciation of the fact, which goes beyond what is Article 52 of the ICSID Convention, but including the appreciation of relevant domestic law. So this would bring back to the appeal the fact of the error on the domestic law of the party, which probably is something that would bring it then as it is in the WTO system, and which is, I think, it's positive. I agree with what Professor Scheuer said about the history, because BITs were not yet on the market, and so there was indeed a difference. And if there were initially only contracts under domestic law at ICSID, then the international law would be the limit to the application internationally of a domestic law which would be contrary to international law. That was one of the purpose of the ICSID Convention. Of course, there was a tension between potential host countries and the countries of the investors. If I may abuse of being here now, that's, I think, one of the issues is that on one hand, you want to, the EU in its proposal wants to have more independent tribunals to rather than ad hoc arbitration by arbitrators that are not always competent and may have conflicts of interest. But where is the protection of the investors here? You said nemo iudex in re propria, but here the parties appoint the judges which will decide cases which systematically are brought by private investors, because that's how the purpose and how the bids are made. Of course, you can say, well, in domestic law, anyone goes to domestic courts, and these are state judges, but there is a procedure, and they look to any case of disputes. Here we have investors that challenge measures of one of the parties of the treaty, and the parties exclusively have appointed these adjudicators. And I think here one should think more. If we have a serious appellate body as we have, then at the first level it could still be arbitrators, or which is a little bit the proposal at ICSID, or having these tribunal mechanisms, but allowing each party to appoint, for instance, not to have to select the European or the American judge, but both the investor and the respondent state be able to select a judge of his own choice outside this, for instance, because there is a question, I would say, of competence, investment concerns, I don't know, oil and gas exploration or financial service. Will these few judges be competent on all this? And from the point of view of the European Union, you have the diversity of 28 states. You may have 5 European judges of 5 countries, and here you are another country, you have its own legislation written in Slovak or in Bulgarian, and the government which is respondent may like to have to be able to pick a judge which is more close to its system. It would be like the ad hoc judge at international courts, which the mechanism is similar. Okay, so excuse me for having gone a little bit
Thank you very
beyond.
much. With a view to the time, I unfortunately cannot allow any further questions. I would like to join me in thanking Laurence and Giorgio for their... Then we proceed to what they usually do in ice hockey, kind of a flying change. I would ask the panelists of the 4th panel to join me here, get wired, and thank you once again for your presentations.
Thank you.
Thank you.